May I please, Your Lordship? Lordship, I am mentioning item number 3. Lordship, in this matter, we have to file the written synopsis. However, Lordship, the synopsis we could not prepare. So 1 week time may be given.
You're for?
I'm for the appellant. Petitioner, Lordship. Petitioner. I'm appearing for GHDC, Your Lordship.
You're also not ready.
We are ready, Your Lordship.
Have you filed?
No, Your Lordship. No? Because on the last occasion, we need to produce the record, Your Lordship. So we have received the records. My senior will be appearing, Your Lordship.
Have you received the record?
Yes, Your Lordship.
Then you're saying that you have to file
written synopsis, Lordship. The petitioner have to file. Because as per the last
okay, then we'll do one thing. Where's your senior? He's not here. We'll wait, let the matter be called up.
Your Lordship. You please, Your Lordship, I beg to mention item 6. Lordship, I'm paying for some accommodation, Lordship, for today, this matter. I'm paying for 2 weeks' time, Lordship.
On pre-made by petitioner, this is matter after 2 weeks.
After? Please, Your Lordship, I'd like to mention item number 4.
This is the matter that is pending before the division bench.
Yes, Lordship.
Matter has not been disposed of.
No, Your Lordship.
On pre-made by the parties, seeking accommodation on the ground that a similar matter which will have a bearing on the merits of this case is pending before the division bench. Matter is accordingly adjourned. This is same after 6 weeks.
Pleasure, Lordship.
Your Lordship, I beg to mention item number 8.
8?
Item number 8. I pray for 2 weeks' time. And for the petitioner.
What is this case about?
Land issuing of land, illegal issuing of land holding certificate.
Oh, okay. The village.
Yes, Your Lordship, Namdong village.
Namdong village.
Are you also there, Mr. Novi?
Your Lordship, I appear for the District Council 1, 2, 3, and 6.
Your Lordship, I'm appearing for respondent 7, Your Lordship. Your Lordship, I have objection in this matter, Your Lordship, because time and again they have asking adjournment, Your Lordship.
Your Lordship can hear it on the next date, Your Lordship, because there's a status quo order operating also at present.
So that would adversely affect you.
I'm not appearing.
Your Lordship.
You're a respondent.
7, Your Lordship.
7. Who is the respondent, sir?
He's the pro forma respondent, Your Lordship, the Doloy.
Is he the one who has issued the sanat? Or the land holding certificate?
Sanat. Land holding.
That land holding certificate is issued by the District Council.
We have issued the land holding, Your Lordship, on the basis and recommendation of the Deloitte, Your Lordship. So now the petitioners are aggrieved by the issuance of the land holding. So this court has ordered some restraining order on the last occasion, Your Lordship, and thereafter it was modified to a status quo order whereby some miscase was filed by the private respondents. There were some activities going on in the land, Your Lordship.
So the alienation or selling of the land has been
nothing as such, Your Lordship. It seems, Your Lordship, the petitioners, it seems they have encroached into the land and made some activities are going by whereby the private respondents have filed a miscase before this court. And this court has ordered a status quo. Now status quo also, Your Lordship, is quite confusing because if they're doing something, they'll continue to do something.
Let's ensure that we take up the matter. Otherwise, if it goes on like this, nothing is, it'll be unending.
Your Lordship, Learned Senior Counsel is out of station.
So 2 weeks, sir.
2 weeks.
Let it be next week, my lord. The difficulty is this, my lord. There is 2 order of status quo. Just, my lord, I will just point
I
out.
think Mr. Nombri has explained.
What they are doing, my lord, forcefully, they are digging my land, my lord. I have purchased it.
Oh, who are you?
I'm the land. Now I'm the owner of that land, my lord. The villagers is claiming that their land, my lord. Whereas I have purchased, I have a land holding certificate, my lord. Now in the land holding certificate, my lord, there was a typographical error. Because of that, my lord, they are saying that no. Like for example, my lord, if the land was 1 acre, my lord, there is a typographical error. It is half acre, my lord. Now they are not allowing me to do anything beyond a half acres, my lord. And villagers, my lord, what right they have? They cannot claim that it is a land belongs to them when it is a private land, my lord. It will be 1 week, my lord, next week.
1 week.
It's all a disputed question of facts, Lordship.
And moreover, my lord, it is not maintainable. The writ petition itself is not maintainable,
We'll look into that.
my lord.
Accommodation has been sought for by the petitioner on the ground that the learned senior counsel who is conducting the matter is out of station. Accordingly, on premium, the same is allowed. Matter is adjourned. This system after 1 week.
May it please your Lordship. Lordship, I beg to make a mention of item number 9 to 13, your Lordship. It's a joint request from both the parties.
Joint prayer, my lord. This matter can come after 2 weeks, Lordship.
9 to 13.
9 to 13, your Lordship.
This is
That, my lord, quashing.
what is the stage? Actually, I've lost track of this matter.
Here, my lord.
Yes.
Here,
The petitioner, some of the petitioner have been heard.
Yes, Lordship.
Yes, Lordship.
Your
Mine was part heard, and we're supposed to file some documents, my lord. That we will do it, my lord.
Yes, your Lordship. In criminal petition number 36 of
it
2000.
would be on the part of the petitioner to respond to your, I think, your argument.
Your Lordship.
Actually, my lord, they were supposed to file the written argument.
Yes, your Lordship.
They're pending for written argument, my lord, written notes.
Okay.
In respect to their petitions, in respect to my lord, I'm supposed to file some documents.
This also, I think, we are just.
But my lord, trial is proceeding, my lord. Trial is proceeding, my lord.
We'll wait till the
No.
final order.
Yes, Lord.
If you are convicted, matter ends there. If you are acquitted, matter ends there. Yet again, on joint requests by the respective councils for the tribal parties seeking accommodation on grounds of their respective personal difficulty, matters adjourned. This is same after 2 weeks.
Deeply pleasure.
Similar prayer for item number 14 to 18 as well, your Lordship.
I think here also we are not keen. You are the one who has filed an application for cancellation of bail. The parties are in attendance in court. They are ready to be heard. If your application is allowed, they are willing to, rather they will be compelled to surrender themselves. But you are not pressing the matter.
Your Lordship, due to some personal difficulty, your Lordship.
This is 14 to 18.
14 to 17, your Lordship. 18 is also a similar matter, your Lordship. But the council is different, your Lordship, in item number 18.
18 comes from a different case, your lordship.
Okay.
Similar proposition but different case.
Yes.
Oh, okay. So this 18 will be heard.
No, your Lordship, I'm praying for item number 18 as well, your Lordship.
I miss that counsel appearing for the petitioner, Union of India, has sought for. What is your ground?
Due to some personal difficulty, your Lordship.
On whose part? Your part.
Yes, your Lordship.
On the ground of personal difficulty of the land council. The prayer is not objected to by the respondents. Seems allowed. This is matter up to 3 weeks.
Highly pleasure.
Much obliged, your Lordship.
Your Lordship, I'd like to mention item number 2 on behalf of the leading law.
Number
2.
Practically nothing is there. Nothing is left for this court to hear. You're appearing for?
Petitioner.
I'm from the respondent, no objection at all.
Your Lordship, if you could,
What is your
for
ground?
2 weeks. 2 weeks' time.
What is your ground? On what ground have you asked for
Oh,
adjournment?
the senior counsel is out of station.
Ms. Learned Counsel, appearing for the petitioner, has sought time for a certain adjournment on the ground that the learned senior counsel who is conducting the matter is out of station. The prayer not be objected to by the respondent. That is adjourned. This is the same after 2 weeks.
No obliged.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 7. Your Lordship, we pray that we 2 weeks' time in this matter, Your Lordship. Dr. N. Mosika is not being able to appear, Your Lordship.
Practically nothing is left. You're for? Respondent?
Respondent number 1, Your Lordship.
Yes.
Lordship, they've been asking time and again, Lordship. If the matter can be given a maybe they can give the fixed date, Lordship. We can have it on next date.
We have gone through that exercise many times. In fact, this court has impressed upon the party. Take it up. Though this court more often than not is very reluctant to pass a specific order. Giving last. Invariably, nobody heeds that except heavy cost is imposed. Now it's time to
Maybe it's time, Lordship.
impose cost. Mr. Learned Counsel, appearing for the respondent, has sought for accommodation in this matter on the ground that the Learned Senior Counsel who is conducting the matter is out of station and could not appear in court today. Mr. A.H. Harwalang, Learned Additional Senior G, appearing for the state petitioner, has submitted that this matter is pending for quite some time, and as such, the respondent may be directed to ensure that the same is heard, that the hearing is taken up expeditiously. Accordingly, on prayer may the same is allowed, matters adjourned. This system after 2 weeks.
I do oblige.
Daily list, item number 1.
Lordship, I appear for the respondent number 4. Your Lordship, this matter was heard and Your Lordship was pleased to direct for filing of written argument. So, Lordship, I'm praying for some time to file my written argument. Not yet ready, Lordship.
I will also pray a
Is
similar
it-
prayer, my
but
lord.
you're,
The record I have received, my lord. Record I have received. I have also similar prayer, and I will.
have you classified the record?
Yes, yes.
Have you?
Yeah.
You know,
Yes, my lord.
you flag mark the.
I have flag mark, and I will make a note, my lord, which page is what, my lord, so it will be easier for my lord to go through.
The petitioners have not yet filed the written argument.
They have
notice.
also not yet filed that.
How long?
1 week time, Lordship.
Mr. SD, Leonard, standing counsel for the respondent JCDC, has submitted that the records have been received by him. However, the Leonard SC would submit that the records may be allowed to be produced before this court along with the written argument to be filed by the respondent, by this respondent, and by the respondent JCDC. Similarly, the legal counsel for the petitioner as well as the legal counsel for the respondent number 4 have also sought for some time to file the written argument. Accordingly, on premiere, the same is allowed. This is matter after 1 week.
Obliged, Lordship.
Item number 5.
Obliged.
Please, Lordship. This is a service matter, Your Lordship, whereby the petitioner herein was terminated, Your Lordship. The allegation against the petitioner herein is that petitioner have not followed the COVID-19 instruction by the government, but in the show cause notice there is no specific allegation or making a specific statement that some instruction, particularly from the GHTC country, where they have to specifically have to follow the instruction. The allegation was saying that on a particular date, not only me, there are 8, including the petitioner. They have gone to the one particular GHTC premises, and they have the meeting. And the meeting was called by the association of the petitioner, this one, and then they have decided, means like they want to call some kind of strike or agitation against for non-payment of salary. And then the meeting went up, and then there is not only the petitioner, there are executive member, there was 8 of them. Then after that, show cause notice was issued to all the 8 of them, including me, the petitioner. Then after that, on the minute of the meeting, JCDC executive member have decided me terminate. But however, my lord, very interestingly, reinstate, but petitioner herein has not been reinstated. They are saying that. That's why, to that effect, I also have filed the additional affidavit, whereby the one of the was accused of violating the COVID-19 was reinstated. And it's from the record, it is all the 7 were reinstated. But the allegation is the same.
So the allegation is basically only for violation of the COVID-19.
Yes, COVID-19. They stated that in the common statement, they are not specific. They said that we have some kind of propagate.
What exactly have you?
Exactly,
what
Lordship,
exactly is the charges against you?
Actually, there is no specific charges against me. Only the show cause notice was there. Only show cause notice was issued. Then I filed a reply, and on the basis of the my reply, they have stated that my show cause reply was unsatisfactory. That's why they have terminated. That is the whole case, my lord.
So no proper procedure was followed.
No proper proceeding was followed.
No proper proceeding, disciplinary proceeding was.
Yes, Lordship. Yes, that was not there. Only the show cause, Lordship. Even my learned friend will agree to that, because.
My lord, this is not a correct thing, my lord. My lord, in this matter, what happened of the petitioner? My lord, may kindly come to page 11, my lord, annexure 1.
Yes.
Now, the Executive Committee, Garo's Autonomous District Council, is pleased to appoint so and so and so and so. The second name, my lord, as the post of lower division assistant in the scale of so and so plus allowances and admissible under the rules and post them to the tax department so and so, my lord. The appointment is purely temporary and liable to be terminated without any notice or assigning any reason thereof. First thing, my lord, whether show cause would be required or not, that will satisfy, my lord. Yes, we have given the show cause. Chance was given to him, my lord. The background of the case is this, my lord. In the district council, due to financial crunch, my lord, the salary was not paid. Now the petitioner has led a mob, my lord, and there was lots of problem created in the district council office, my lord. In the district council office, they have created, now, my lord, they have made it a political issue, my lord. They brought 2 buses of crowd and staff from Garo Hills to Malki Point, my lord. And Mr. Sangma was personally present on that meeting. I have the photograph, my lord. My lord, may kindly see a government employee, can they go for a strike? There is a Tamil Nadu High Court judgment where they say that, my lord, government employee cannot go for a strike, my lord. Now, the appointment was purely temporary, my lord. He should have been very extra cautious, my lord. Now, he led a mob. He has led the staff of the district council agitating against the authority of the district council. Now, my lord, the situation is this, my lord, that the financial crunch is not only for a 4th grade or 3rd grade or 2nd grade appointees, my lord, for everyone. Even the CM, EM and others office staffs, my lord, are not getting the salary. So they created all havoc, my lord. There was multiple cases before this honorable court. And there was an affidavit file also, my lord, where they have tried to torch the district council, my lord. Now, whether we have pointed out those allegations or not in the show cause, my lord, that I would like to take my lords to the show cause notice. But the fact is this, my lord, they are very dangerous, my lord. Whether it will be safe for the district council authorities to keep them as an employee or not, my lord. Now, my lord, may kindly see the show cause notice which has been issued to them. That is on page 13, my lord.
Yes.
Where, my lord, may kindly come to second paragraph, my lord. Whereas it has come to the notice of the authority of the GAGC that several videos has been circulated online wherein you, along with others non-gazetted staff members of the Garo Hills Autonomous District Council, has gathered in protest agitation on so and so in the office premises so and so, my lord. Here, my lord, okay, fine. Till here, my lord, there is nothing wrong on that. Now, my lord, may kindly come to the next para, my lord. Whereas you, being fully aware of the ongoing restriction and lockdown for the COVID pandemic, you have not taken any permission. Even permission was also not taken by him, my lord, whatsoever from then district council authorities or the deputy commissioner West Garo Hills or any other competent authority prior to holding such a mass public gathering. Now, my lord, may kindly come to the 5th paragraph, my lord. 6th paragraph. Whereas you have made several. My lord, got it, my lord?
Yes, yes.
Have made several fabricated, incorrect, derogative and defamatory statement and accusation against the administration and officers or the GAGC during the said speech of 22nd July 2021, my lord, and that you have failed to uphold the integrity as the staff of the GAGC and drastically failed to maintain the image, esteems and reputation of the GAGC in the eye of public, my lord. Now, not only the staff, my lord, they have gathered the outsiders also, my lord, to create havoc, my lord. The building, the premises was locked down and the staff who want to go for a walk, my lord, they was not allowed. They was threatened, my lord. Now, my lord, may I kindly see the next para, my lord, next line, next page, my lord, page 14. Violation of the applicable COVID-19 protocol and norms, thereby endangering the lives of the local resident and public at large. And therefore, the authority of the district council is hereby directed you to reply the show cause notice in writing as to why so and so should not be done, my lord. Now, my lord, see, interestingly, my lord, his reply, my lord, where he challenged our authority, my lord. His reply is on page 17, my lord. If I am permitted to read, my lord, that before replying to the show cause notice, the undersigned beg to submit herein that in your show cause notice, you have clearly mentioned that we have not taken any permission from the authority of JGDC or from the Deputy Commissioner for holding the meeting and public gathering. Secondly, you have mentioned that we have not adhered to the COVID-19 norms and regulations restriction issued by the competent authority. And in answer, reply to your charge, statement, allegation, the undersigned humbly beg to submit that whenever the central government, state government, health department issued a notification, norms, guideline, restriction, and any COVID-19 to the public, they have issued that all the citizens of the country have to follow the same irrespective of their status, position, that is to say, the government, bureaucrats, office, minister, etc. have to follow the same. And it is pertinent to mention here in that time and again, this notification, norms, guideline, restriction, and any COVID-19 protocol have been issued by either by the central government or by the state government since from the month of March 2020. But shockingly, on 4th June 2020, when the employee and the staff of JGDC under the banner of NGEA were holding series of agitation. He is admitting, my lord, that he has held a series of agitation for non-payment of the salary. The CEM of JGDC has called and invited the different NGOs, staff, employees of JGDC for general meeting and for dialogues. But interestingly, at that point of time, no COVID protocol norms, restriction, guideline like social distancing, wearing mask, hand sanitizing, washing of hand, etc. were never followed. And even your good office, who is the principal secretary of the executive committee of the JDC, has never issued any guideline and COVID-19 protocol to be followed on 4th June 2019. Now, my lord, he has created a havoc, my lord. He brought the outsiders, my lord. So we have invited those NGOs and all, my lord, who are the welfare, who are the people who are interested in the welfare of the district council, my lord. We have called them, my lord, for the meeting because they have created all the ruckus, my lord, in the office. Now he is objecting there also that why you have not maintained the protocol, my lord. They are challenging our authority, my lord. Now, my lord, may kindly see the second paragraph. Secondly, according to your statement in your show cause notice, it's mandatory to follow the COVID-19 norms and protocol, which further indicated that you want to ensure that no employee staff of the JDC should be infected by the COVID-19. But interestingly, your good office have never taken initiative. How many staff MDCs has been vaccinated and how many staff, including MDC, have been vaccinated, and your good office also have not taken any step to find out how many staff employees are infected and have not taken initiative to support and supply the medical assistance to those who are infected, tested positive on coronavirus. But when the undersigned along with the other members of the NGEA were having some important discussion to apprise the CEM of GIC to take up the matter on implementation of the Meghalaya 5th Pay Commission, and you have issued a show cause notice seriously alleging that the undersigned and the members of the GIC have violated so and so, my lord. Now, my lord, may kindly see, now he is asking us what we have done, whereas he should have said, my lord, okay, maybe I have committed a mistake, please forgive me. Instead of that, my lord, he is challenging us, my lord. Now, show cause notice was given, my lord. Reply was given, and we say that, my lord, it is not satisfactory. We have terminated him. His appointment was temporary, my lord. Now, my lord, can my lord go into the merits of the case, saying that, my lord, whether the termination was proper or not? My lord has to examine only one part, my lord, that whether the natural justice was followed or not. Principle of natural justice. Here it appears to be followed, my lord. We have given the show cause, and his reply speak volumes, my lord, where he challenged our authority, my lord. I have few judgments also to that effect, my lord.
See,
my lord,
you have got the point,
my lord.
Now, this court will not go into the facts of the dispute. The only concern of the court would be to see if there is any violation of the process.
Yes, my lord.
You go back to your show cause.
My lord.
page 14. So here you have directed the petitioner
Yes, my lord.
to reply to the show cause notice.
Yes, my lord.
Then the last line says, which may lead to further disciplinary proceedings.
Yes. In your absence.
In your absence or
Yes, my
presence,
lord.
doesn't matter. If he fails to appear,
My lord.
it's a different thing.
My lord.
See what this entails.
My lord.
Is that a proceeding has to be followed. Disciplinary proceeding has to be followed.
My lord.
Show cause notice issued, show cause notice replied.
Yes, my lord.
Thereafter, what is required to be followed?
Yes, my lord. Exactly.
A
my lord.
proceeding has to be initiated, where you have to appoint an inquiry officer,
My lord.
presenting officer,
Mhm.
witnesses, documents,
they-
all those.
Yes,
see,
madam.
that I
But-
think that need not be spelled out to you.
Yes, yes. my
That
lord.
is no.
Exactly. my
Whether
lord.
that process has been followed or not.
Exactly, my lord. Now the question is this, my lord. When the matter was show cause notice and all was given, my lord, and he has replied and all, the matter was followed. The matter was placed before the executive committee, my lord. The executive committee, my lord. Now, whether those steps was followed or not, my lord, I have to take the instruction, specific instruction. But my lord, might kindly consider he is a temporary employee, my lord. Now, I have a judgment.
That also, you see, you produce the judgment or
Yes, yes,
authority,
yes.
which is that if he is a temporary employee,
Yes.
you need not go through all that.
Yes, exactly, my lord.
So
Exactly.
even then, you see,
Yes.
the principle of natural justice, or rather, principle of justice,
My lord.
would require that a person has to begin every opportunity.
My lord.
I've noticed, I've noticed such kind of orders that have been issued from time to time, appointment orders,
Yes.
which says temporary appointment is purely temporary
Yes, my lord.
and liable to be terminated at any time without notice or assigning any reasons.
My lord.
I think this appears to be very, very harsh.
No, I bow down, my lord. But the fact is this, my lord. This appointment, when it was issued, it appears to be very harsh. What has fallen from my lord, but it has been accepted, my lord.
It has been accepted.
It has been
but
accepted.
we have to see. You see what, like again, I'm saying I'm not. You see, I'm not too conversant with the subject.
My lord.
You will be.
No, my lord.
You see, if there are authorities to support you,
My lord, I will
in this
definitely
regard,
place. And
similarly, Mr. Samas, who would
yes,
file his authority,
my lord.
then the matter can be.
Yes, my lord.
If you see at any point of time, even at this stage, if you say that yes, we need to initiate a proper inquiry, do it.
My lord.
We are not. You see, the court will not say that he is right, he is wrong.
My lord.
His action is proper, not proper. That is not for the court.
My lord.
You see, it's only whether you have given him the full opportunity
My lord.
to be heard.
My lord.
So to that extent, I think that would be
My lord.
concern of the court.
Yes. Now, my lord, may kindly see the termination order that is on page 29.
Yes.
The executive committee is pleased to terminate the service of so and so and president of NGEA, who is under suspension of taxation department for unsatisfactory reply to the show cause notice issued so and so date, and challenging the authority and counter allegation in nature with immediate effect. As per the terms and condition of the appointment order, which read as the appointment are purely temporary and is liable to be terminated. Now, my lord, that is what has fallen from my lord. I
have not gone through this, but it appears. I think this is subject to argument.
Yes, exactly, my lord. Now, my lord, I have to satisfy this honorable court whether the procedure has to be followed or not, or is just like a principle of natural justice has to be followed. Now, if there is an authority to that, I will place, my lord, and my learned friend can also argue on that point.
Yes, Lordship. Let him
In
please.
fact, Mr. Day, I think even here also, of course, if you can satisfy this court, well and good.
My lord.
Otherwise, records may be required.
Yes, my lord.
If
yes,
a procedure has been followed, which
yes.
has not been reflected in the
order,
you
yes.
file your counter.
Yes. Only thing is, my lord, I can say with all sense of humanity, my lord, that the gentleman, my lord, he was not in a correct position, my lord, to deal with the situation where, my lord, even there was an attempt for ablazing the.
You see, that would be for the authorities, relevant authorities to
Yes,
consider.
my lord.
If a proper procedure has been followed and he is found to be guilty,
My lord.
as charged, it's up to you to impose punishment.
My lord.
But the only thing is that let the procedure be followed, that he be satisfied that he has been given maximum opportunity to be heard and to defend himself. There are cases, for example, of a, you've done that many times, of a armed force personnel, police personnel, who have, because of their indisciplinary conduct, they've been terminated from service. That is acceptable because they belong to a disciplined force. Unauthorized absence, misconduct,
Yes, my lord.
fighting,
Yes.
Consuming
Alcohol in
all
duty.
those things. We are not into all those facts.
Yes.
We are on the process.
Yes.
So we'll take it up after 1 week.
Lordship.
After one, because I have to call for the record also. I will pray for some time, my lord, because I need to do some research also on this regarding that whether a straitjacket formula can be applied
Yes.
or not.
2 weeks then.
Lordship.
When this matter was called up for hearing, the learned counsel for the parties has submitted that sometimes it's required for the matter, sometimes is required so as to enable the parties to produce relevant authorities or precedents to support their respective contention. SD, Learned Standing Council GHADC, has also submitted that if so required, the relevant records of the department will be produced before this court. As prayed for, the hearing will continue after 2 weeks.
Lordship, in the meantime, may I be allowed to just my written argument or just?
That's what I said.
Yes.
You have any authority?
Yes, Lordship.
Yeah, you have any written argument?
Yes,
you do
Lordship.
it.
Yes.
But the
The
case,
next-
as it is a very straightforward case.
Yes.
We'll see what the law says and what
Lordship.
the procedure says.
That's it.
Most blessed Lordship.